We've got a major shift happening in one of the most critical courtroom showdowns over so-called assault weapon and magazine bans. The Trump administration has officially stepped into the legal fight against Illinois' firearm restrictions, stating that these laws flat out violate the Constitution. At the same time, Illinois is digging in and doing everything it can to stall the process. Let's unpack where things stand right now. Before we dive into the legal weeds, do us a solid tap that subscribe button and give this video a thumbs up. It doesn't cost a dime, and it helps this pro-Second Amendment content reach more folks who care about freedom. And hey, if you drop a comment down below backing the message, it tells the algorithm this content matters. All right, so here's what's going on. Illinois passed legislation banning semi-automatic rifles and so-called high-capacity magazines, essentially the same kind of gear millions of law-abiding Americans own. This law, known as the Protect Illinois Communities Act, or PICA, is being aggressively challenged in federal court. The Trump team just filed an amicus brief in support of the folks fighting back, arguing that these bans directly clash with the rights guaranteed by the Second Amendment, especially when we're talking about widely used rifles like the AR-15 and magazines that hold the standard 30 rounds. Right now, this case is back in front of the Seventh Circuit Court of Appeals. Illinois is trying to reverse a previous ruling by Judge McGlynn, who struck down PICA after finding it unconstitutional. His decision came down hard in favor of gun owners. But now, the state wants that judgment tossed out. That's where the Trump administration came back into the picture. They're telling the appellate court to keep Judge McGlynn's decision in place. Their argument? Banning the most commonly owned rifles and the standard magazines that go with them goes directly against everything the Second Amendment stands for. But Illinois isn't giving up. They've now asked the court for an extra 30 days to file their response. They say they need more time to deal with the Trump administration's brief and the other filings from Second Amendment advocacy groups. In other words, they're stalling. Earlier in this legal fight, several lawsuits were filed at the federal district level, and those judges temporarily blocked enforcement of the law. But Illinois quickly ran to the Seventh Circuit, which overruled those injunctions and brought the ban back to life. That move pushed some plaintiffs to file emergency appeals to the Supreme Court. Now, the High Court didn't jump on the case right away, but Justice Clarence Thomas issued a statement that turned some heads. He made it clear that if the lower court lets Illinois keep banning the most commonly owned rifle in the country, the Supreme Court should step in once a final decision is handed down. His warning was crystal clear. The Second Amendment is not a second-class right. While all that was unfolding, Judge McGlynn worked to fast-track the challenge so it could be decided based on the full legal merits, not just emergency measures. And once again, when the time came, he declared the entire PICA law unconstitutional and said it had to be thrown out completely. Naturally, the state didn't take that lying down. They filed yet another appeal with the Seventh Circuit, this time doubling down on their usual talking points, that AR-15 style rifles, removable magazines, and related accessories are supposedly weapons of war and therefore not protected by the Constitution. That argument has been debunked more times than we can count, but Illinois is sticking to the script. Now the ball's back in the court of the Seventh Circuit, which already showed its anti-gun leanings when it reinstated the law during the earlier injunction phase. Still, this fight isn't over, not by a long shot. With increasing pressure from pro-Second Amendment voices and strong legal support from the Trump administration, this case could be headed for the Supreme Court, and the final word on whether states like Illinois can keep ignoring the Constitution. Now this is where the temperature really rises, because the Trump administration, through the Department of Justice, just officially stepped into the ring and is backing the lawsuit against the Protect Illinois Communities Act, also known as PICA. In a newly submitted amicus curiae brief, the federal government came out swinging, declaring that this law is outright unconstitutional. In that filing, they pointed directly to a pivotal Supreme Court ruling from 3 years ago, a decision that made it crystal clear. The Second Amendment is not some optional policy suggestion. It is a core constitutional right. But apparently, Illinois didn't get the message. Just months after that ruling, the state pushed through one of the most far-reaching bans in the nation, outlawing firearms and magazines that millions of responsible Americans legally own and use. The Trump administration's position is straightforward. Illinois is going against the very guidance the Supreme Court laid down. The court said, in no uncertain terms, that the government cannot ban firearms that are widely owned and lawfully used. And yet, here we are. When a lower court issued an injunction to block enforcement of PICA, the Seventh Circuit reversed it, claiming the law was probably constitutional. Even then, the appeals court admitted that was only a preliminary view, not a final determination. Now the Trump administration is urging that same court to take a second look and leave the district court's injunction in place. They outline 3 major reasons why that earlier ruling needs to be overturned. First, they argue that the earlier decision, known as B's, messed up the core analysis under the Second Amendment, even when considering the legal precedents available at the time. Second, several justices on the Supreme Court have made it known that they don't agree with the reasoning in B's or other similar rulings from lower courts. There's growing expectation that the High Court is gearing up to clarify the standard once and for all. Third, after the B's decision, the district court ran a multi-day trial, examined the facts in detail, and ultimately ruled that bans on widely owned semi-automatic firearms and accessories used by law-abiding citizens for legal purposes are unconstitutional. In short, the Trump team is saying loud and clear, the Seventh Circuit got it wrong and needs to reverse course. This isn't just a strong legal argument, it's a full-throated defense of the Second Amendment from the highest levels of federal authority. Digging into the details of the brief, the Department of Justice makes one critical point. The Second Amendment protects arms, and the question here is whether these banned rifles meet that definition. Their answer? Absolutely. Rifles like the AR-15 are unquestionably arms as recognized under the Constitution, and the federal government is now on record saying exactly that. They even reference recent Supreme Court cases, like the one involving Smith and Wesson under the Protection of Lawful Commerce in Arms Act, where justices, including Clarence Thomas and Elena Kagan, acknowledge that rifles such as the AR-15 are commonly owned and frequently used for lawful purposes, like home defense and recreational shooting. The Trump administration also called out the flawed reasoning used by the Seventh Circuit, especially its reliance on the so-called military-style test. They argue that kind of framework doesn't align with the Second Amendment, nor with the precedents set in the Bruin decision. The Constitution doesn't make exceptions for firearms based on whether they look tactical. They took it a step further to reminding the court that, historically, private citizens were expected to show up for militia service with their personal firearms. That means the same rifles people use for home protection today were once expected to be battlefield ready if the nation called. So the idea that these types of weapons aren't protected under the Second Amendment isn't just wrong. It flies in the face of the founding intent. When it comes to magazines, the Trump administration isn't backing down there either. Their brief made it clear, PICA isn't just a problem because it targets rifles. It also oversteps by banning standard capacity magazines. According to their argument, the Second Amendment doesn't just cover the gun. It also protects essential components, like magazines that are critical to exercising that right effectively. The federal government is also drawing a firm line in the sand when it comes to vital firearm accessories. They're making the case that even if items like detachable magazines or sound suppressors aren't technically classified as arms in the narrowest legal sense, they're still essential for the lawful use of firearms, especially when it comes to self-defense. According to the Trump administration, components that are commonly owned and routinely used by law-abiding gun owners, things like standard capacity magazines, suppressors, and other everyday attachments, should be recognized as protected under the Second Amendment. And that's really the core of the argument. The federal government isn't hedging here, they're going all in. They've made it clear that standard magazines, suppressors, and widely used firearm parts are covered under the constitutional right to keep and bear arms. Now, the legal filing contains a lot of detail, but even this overview gives you a sense of how strongly the Trump administration is opposing this ban. On the other side, the state of Illinois is trying to slow everything down. They've just requested an extra 30 days to submit their response to the briefs that have been filed. Their excuse: they claim they need more time to deal with all the legal points, not only from the plaintiffs themselves, but also from the Trump administration and several other pro-Second Amendment groups that have filed amicus briefs. In their motion, Illinois officials argue that they're overwhelmed by the sheer volume of arguments, more than 200 pages of legal content spread across 4 primary briefs, and another 4 friend of the court briefs. They say that's far more than what is typical for this stage of a case, and that they can't address it all in the normal time frame. But let's be real, this smells like a stall tactic. They know the legal pressure is mounting, and with the Trump administration throwing its weight behind the case, Illinois is clearly feeling the heat. Still, no matter how long the state tries to delay, they will eventually have to confront every single legal argument being made against this unconstitutional law. And all eyes are now squarely on the Seventh Circuit Court of Appeals. Now, if you're wondering where I stand on this, here's the truth. Based on the court's history, I wouldn't hold out hope for a sudden turnaround. The Seventh Circuit has not exactly been a champion of Second Amendment rights lately. When they reversed earlier injunctions that would have blocked the Illinois ban, they showed a disturbing disregard for both the Constitution and clear Supreme Court precedent. So, yeah, it wouldn't shock me if they doubled down and upheld the ban once again. But here's the wild card. Justice Brett Kavanaugh has already signaled that the clock is ticking for lower courts that refuse to follow the Second Amendment standards laid out in Bruin. He strongly suggested that it won't be long before the Supreme Court takes on one of these cases directly. In fact, when the High Court declined to take up emergency appeals in cases like Snope and Ocean State Tactical, they specifically pointed to this case out of Illinois. That means the justices are watching, and if the Seventh Circuit continues to ignore clear constitutional limits, this may be the case that finally goes all the way to the top. So, to wrap things up, Illinois is dragging its heels, hoping to outlast the growing momentum against its unconstitutional firearm restrictions. But this fight is just heating up. As always, I'll be right here to keep you updated as the legal battle unfolds. Thanks for tuning in, Patriots. If you got value out of this, go ahead and hit that like button. Drop a comment to help spread the word. And make sure you're subscribed so you don't miss the next update. This country was built by freedom-loving Americans, and it's going to take that same spirit to keep our rights intact.